Good afternoon, Your Honors, and may it please the Court. Ben Lewis from the Rutherford County Bar. If I may, I'd like to reserve 4 minutes for my rebuttal.
4 minutes, yes, sir.
Thank you, Your Honors. Your Honors, we're here this morning in the matter of Bailey v. Bailey, which was a divorce hearing that came out of Warren County General Sessions Court, I apologize, General Sessions Court, and resulted in several findings. And our issues here today, Your Honors, the major one centers around the parenting plan that was issued in this case, but ultimately goes to the order itself in that it failed to make sufficient findings of facts to support really most of the findings, although some of those are not in contest here today. First issue, Your Honors, is that we contend the parenting plan as issued, which established the mother as the primary residential parent, was one, incorrect, but that's understandably a difficult mountain to climb in the normal circumstances. This court looks at a parenting plan and, as the appellate court, grants significant deference to what the trial court finds because it's better positioned to make the findings of fact, better positioned to determine credibility, and just overall better positioned to make those determinations than this court would on an appeal. And that's the normal standard we work on. However, what that requires, Your Honors, is that the trial court make findings of fact that this court can look at. I'll jump forward a little bit to an argument that's made in kind of contrast to what my argument is, which points to my occasions to be in front of this court in other cases, one of those being Guggenhauer, and another one being Friedman versus Kreisel, which was a couple years old now. But in that case, Your Honors, Judge Rogers out of Rutherford County had made, I believe, if I recall correctly, it was about an hour and a half long ruling, but ultimately he failed to make a finding of fact this court found was very pertinent as to restrictions in the parenting plan, and overturned that case and sent it back. And despite his findings of facts, painfully long in some occasions findings of facts, this court said, well, you didn't find the facts that we need to determine what occurred, so he remanded it and told the court to make those findings. Under Rule 52.01, any trial court in making any determination is required to set forth those facts specifically in an order, or if it makes them orally, would be put into an order by the parties. The underlying...
How detailed does it need to be? I mean, it seems like the trial judge did go through each of the factors, made some determination as to each of the factors touched upon. How detailed does the trial judge's order need to be adequate?
And that's a good question, Your Honor. When you look at it, it's almost like saying this court has to determine what is the level of findings of facts that the trial court is then required to make, and it's a difficult standard, and I understand that, but what we see in the trial judge's order in this case is just generalities. And I think in my brief I cite to the pleading standard, kind of akin to a pleading standard in a complaint, is that if I was to take some of these generalities that are placed in the trial court's order, such as just simply mother has historically performed the majority of the responsibilities, father's done an amazing job, both parents had some animosity. If I was to take those, place them in a complaint and file it, a 12.026 motion would probably get rid of that because it's not, I don't even have enough to reach a pleading standard. So when we look at that, Judge, my questions become, what has the mother done that would justify her finding that she's historically performed responsibilities, the majority of them?
Well, she had 70% or so of the parenting time that's been hers?
She had, Your Honor. But
isn't that consistent with the finding of the trial court?
It is, but it's not consistent with what the ultimate facts bore out, in that even though my client, Mr. Bailey, had less parenting time, he did all of the doctor's appointments. Even though he had less parenting time, he took the children to their extracurricular activities.
Well, can we surmise, though, from the fact that the court doesn't reference those? I mean, I appreciate that your client thinks those facts are important.
Yes,
Can we surmise by the fact that the court doesn't include specific findings about those points? It really didn't feel like they were important.
You could if there were other facts cited to, Your Honor. I think if the court had said, I make the findings of facts such as mother, for example, mother did feed them dinners, mother did take them to school every day, mother did do this, mother did do that, but left out the other facts over here that father asserts. If it made findings of fact, but just left out what father said, then I could understand where certainly that would be the case. But our position is that there's no recitation of any facts other than just generalities made here that say, here's kind of the category I find this to have occurred, but I don't find what facts support that finding. For example, and I have the copy of the order here, Judge, Your Honors, I went through it and looked at it myself. It says both parents hold some animosity toward their spouse. Well, what in the record supported that, Your Honor? Certainly they did, but where do you come to that conclusion? That is a conclusion that doesn't have any facts cited to support it. When you get to, there were disappointing episodes with the stepchildren on father's behalf. Well, what were those? When you say mother's not done all she could to cooperate with the father, what has he done? Again, if I was to state those in a complaint, I think the Court of Appeals, or any court would look at that and say, well, that's just simply a conclusion couched as facts, is all it is. And that's really all the trial court has done, is to go through here and say that. And then we get to, Your Honors, let's see. There's 3 of these in here, 3 of the categories, 4, 5, and 6, that the court simply just lumps together and says both parents are capable of providing the necessities for the children. The mother didn't work. Mother has not provided any necessities outside of what father has provided her. Again, these facts don't exist within the findings of the court. And that's where we come to Rule 52.01, is that if this court, as we suggest, finds that this order is insufficient to provide a factual basis for the finding, then what I'm asking this court to do is essentially do the trial court's job, is take a look at this, and this court has 2 options. It can do its own de novo review and determine where that preponderance of evidence level is. Does it weigh in favor of the mother? Does it weigh in favor of the father? And that's why I've tried very detailed to go through each factor in my brief that sets forth where we think that preponderance of the evidence would lie if this court was to review it. Or this court could take the other avenue, which is to simply say, well, trial judge, which is what happened in the Friedson case, is Your Honors took it and said, you need to make a finding of fact on this issue right here. And Your Honors could certainly remand it down and say, you need to make findings of fact specifically on these issues. But I would submit that would be all of those.
Counsel, if the court does go that route and is soldiering on here, and isn't there a pretty strong basis for the trial court, what the trial court did here? I mean, mom's, essentially, there's a fair amount of testimony. The mom's a good mom of these kids, and that she has essentially, dad is working extensive hours. And so the trial judge deciding to work custody to mom makes some sense given that. And is that, if we are soldiering on, why is this a wrong decision?
Well, if Your Honors are soldiering on, it becomes a much more difficult burden on my client's behalf, because if the court soldiers on and says there are sufficient findings of facts, then it's our burden to then prove an abuse of discretion on the trial court's basis, and that's admittedly a very high hill for us to climb. And in that case, while I would disagree on father's working hours, he does testify at the time of the trial that he had removed a large portion of what he was doing. They brought him up to 12 or 16 hours of working time. He had lost essentially a second product line had been given to another employee, and his 12 to 16 hours had been reduced at that time. He does testify to that. It happened very recently before trial. But he worked from home. At the time, he was perfectly capable of taking children to school, getting them home, doing all that. But when the court looks at, if you say it's a 75-25 or 70-30, what have you, I think it becomes a much more difficult argument at that point if the court finds we can soldier on through this. But again, I have to.
The final breakdown here was 53-47 in terms of time, or something close to that.
It's pretty close.
Pretty,
yes,
okay.
it was admittedly. I think it was around 70-30 to start with, and then the trial court gave an additional 48 hours every 2 weeks to my client to bring it closer up to that 50-50. But our position is, if the court is able to look at it and does weigh that preponderance of evidence, the testimony and the proof submitted at trial was, yeah, mom was not necessarily, didn't do anything specifically to harm the children, but our position was father was doing the majority of the parenting responsibilities. He was taking the children to the doctor. He was doing their extracurriculars. He was the only one involved. And then you have the testimony, which admittedly this trial court doesn't have to listen to. It kind of flippantly discounts the expert's testimony and just says, well, it was hired by the father, so therefore it's obviously in his favor. But the expert that was seeing the children and the only person outside of these parents who really testified about what they knew regarding the children. He said that in his opinion, the father needed to be the primary parent because he was more involved. So I think if the court gets to the point where it can weigh that preponderance of the evidence, it would look at this and say, well, father does, all of those factors do fit into his, and weigh in favor of him. And I go back to the Guggenauer case that's cited in an opponent's brief, is that this court kind of slapped the hand of the other side saying, well, you don't just get to count the factors and put them in a box and automatically you win primary parent. That's not what we're saying. In Friedsom and Kreisel, this court said, well, in the event that in that event the mother had all factors favoring her, this court said, well, you need to make some finding as to why then father gets 50-50. So it is relevant, but it doesn't, I'm not arguing and not pretending to argue that that's as simple as just counting the boxes or checking those boxes and saying they favor father and therefore he wins. Just briefly to touch, Your Honors, and I can come back to it later. I'll concede my time at this point, Your Honors. We won't get into a new point. Thank you.
All right, thank you, sir. Good afternoon.
Good afternoon. Andre Greppin of the Putnam County Bar for the appellee Heather Marie Bailey. This is obviously a very contentious divorce. You have a long-term marriage here that has broken down. You've got two kids who are stuck in the middle. You've got a father who's a very high earner who's historically, throughout the entire marriage, paid for everything, paid all the mother's expenses, paid the children's expenses, and you have a mother who decided to forego her ability to earn a living for herself in order to stay at home and be a homemaker, be a stay-at-home parent for the kids. That's understandably frustrating for the father now who's paid for everything now that the marriage has fallen apart. But that was the deal that this family made. They made it from the very beginning, and that's the deal that they reiterated and stuck to when the divorce was filed. After the divorce was filed, after the parties were separated, the parties came together, they signed a temporary parenting plan, giving the mother primary residential status, giving her 70% of the parenting time, and throughout the year and a half that this divorce was pending in the trial court, the father continued to pay all of the mother's expenses and all of the children's expenses.
You're not suggesting any error in terms of the trial court imputing income to mother, though, here, are you? You're not arguing that the trial court shouldn't have imputed $40,000 a year, I think it was, to her?
I don't know that I've seen any specific authority that says you have to impute income. I don't know that
that was error.
I don't know. I haven't explicitly argued that because I don't know that I've seen anything that says imputing income in this situation would be an abuse of discretion. There are some cases that do it. There are some cases that don't. I think it's left to the discretion of the trial court. The important thing, though, if you look at the spectrum of cases when we're talking about setting alimony, even when you impute income of $42,500 or whatever a teacher in elementary school in Warren County makes, that is still far below the threshold for the spectrum of values that the case law represents. And the perfect example of that is the Folger case. This is a 2016 case. Husband made, I believe, $120,000 to $160,000. Wife made $40,000 to $50,000 a year, and the trial court awarded $2,000 per month in transitional alimony. This court reversed, said that was illogical, said that was far below
What was the testimony in terms of the amount necessary for mother to sustain, maintain her standard of living in this case? What's the dollar figure that the court, that the testimony is going to support the court should have been reaching for or should have set in terms of figuring out the amount of alimony? Here, I know you're objecting to the alimony award. You think it was wrong here. What was the right figure?
I don't believe that necessarily has to be derived from testimony. The evidence was clearly and explicitly in the record. Father brought it in. Father brought in an itemization of mother's living expenses. Father brought in bank statements showing regular charges that mother made. And those alone establish what mother's regular living expenses are. There was no need to offer any particular testimony on it because the parties tried this issue by consent and assumed that the trial judge would consider that and apply that evidence to the facts of the case and the law, which I believe the trial court did, but that the alimony award in this case was artificially lowered by the finding of fault in the trial court's order. What I'm talking about specifically is that the trial court made a finding that mother had engaged in inappropriate relations with people outside of the marriage, and that those inappropriate relationships had caused the divorce. Respectfully, there is no evidence whatsoever that any inappropriate marital conduct occurred, any extramarital affair occurred prior to the divorce. No evidence whatsoever.
Prior to the
What the-
divorce or prior to the separation?
Both. So what I believe the trial court is mistaking in this instance is the incident that occurred with Bobby Mullins. That occurred in May 2021. The divorce was filed
Was there
in.
any other evidence in the record other than that? And there's obviously some disturbing testimony connected with that in terms of mother's assertion about what happened. Is there any other evidence related to other relationships? I hesitant to refer to it as inappropriate given mother's testimony on that matter, but it's inappropriate on Mr. Mullins' behalf. But it's in terms of what we're looking at here. Are there any other relationships the trial court was identifying?
Not from what I can discern. The only other relationship that was discussed, and it was discussed openly, it wasn't hidden, was that mother was in a relationship at the time of the trial with a witness who testified named Gear Gibson. Both mother and Gear Gibson testified that their relationship had been romantic for approximately 3 or 4 months, I believe.
There was nothing before the separation?
Nothing at all before the separation, no evidence whatsoever, which is why this is a clearly erroneous assessment of the evidence on the part of the trial court.
One thing I'm struggling a little bit here is the rehabilitation time period is 3 years. Mother seemed to have not a lot in the way of her being able to go back to teach here. And she had to complete a few additional requirements. She had previously had a teaching certificate. And what did she need to do to be able to teach again in the public school system?
I don't know anything other than what was testified to at the trial. My understanding is she had to reattain her teaching certificate. I'm not sure what steps are involved in that. Certainly there is some action that the mother would be required to take in order to re-enter that profession. But it's helpful when we look at the spectrum of cases that exist on this. There is a case from 2000, Mitz versus Mitz, that involved a wife who was a school teacher who voluntarily stopped teaching, lost her teaching certificate in order to become a homemaker when her children were born. Then later on, the children were almost all out of the house. I think there was one left. Their youngest child was still in high school, and the parents filed for divorce. And during the pendency of the divorce, the father complained, like father in this case, that mother could go get her teaching certificate back at any time and re-enter the workforce. Why do I have to pay alimony to rehabilitate her when she is able and capable of working? And the mother said, I don't want to go back to work right now. I chose to stay at home, to be a homemaker, to look after my children, and that's what I intend to do until my child graduates high school. And what this court did was not vacate the award like father in this case is asking. They increased the alimony award from $2,000 a month for 14 months to $2,000 a month for 4 years. Now, that case was in the year 2000. That was 23 years before the judgment in this case. If $2,000 a month for 4 years or for 14 months is unreasonable in the year 2000, $1,500 a month in the year 2023, 23 years later is certainly
Well,
unreasonable and
I mean,
illogical.
this whole discussion, though, brings up one of my concerns here about the court's order. You're saying the court's order is sufficient. You point to its length, but the length is largely taken up with quotation to the statutory factors, which takes up a fair amount of the order. Our Supreme Court has said that the general rule is that the findings of fact must include as much of the subsidiary facts as is necessary to disclose to the reviewing court the steps by which the trial court reached its ultimate conclusion on each factual issue. There are factual findings here, but what we seem to be missing are a lot of these ancillary facts that led the court to the ultimate fact at issue in the case. I mean, information like how long it would take your client to get her teaching certificate, information on what her need is. I mean, we don't have those ancillary facts here, do we?
I believe there's a caveat to that rule when the answer is readily discernible from the record. For instance, the trial court does not need to make a specific finding and cite to the.
Let's take that thing. What's the figure then? What's the amount? I mean, you say in your brief $5,000 is what's needed. How do I know that from the record, that $5,000? And it seems like Father has suggestions that maybe it's $3,200 or $3,300 in parts of the record. And your 5,000 argument doesn't seem to incorporate Mother having $40,000 a year attributed. How do I know 5,000 is the right figure?
Well, it does incorporate income of $40,000 being imputed to Mother. That was the case in the Folger case. Then from the Folger case, which was $4,000 a month, we have to account for in inflation since 2016, the loss of the time value of money, and the legislative changes that emphasize the value.
The court here used sort of, well, not sort of, unusual language to describe how it arrived at the number. The court feels that $100 or $1,500 a month would be sufficient. I mean, what is that about? Feels that the $1,500 is sufficient? I mean, what does that mean?
Well, respectfully, a lot of the appellate decisions that I've read on this issue make pretty conclusory findings about what is sufficient and, or what may not be sufficient for purposes of alimony. So I don't think that's out of the ordinary. Yeah. Although I do think it's incorrect, and I think you can tell from the face of the order that it was artificially reduced by this incorrect factual finding that.
Or incorrect feeling is what you're suggesting.
It must have been a feeling, because it's certainly not in the record.
Okay. Why, based on the findings, why did Mother receive custody in this case? Why is this 53% mom rather than 53% dad in terms of the decision here? So I mean, and that certainly has to be, we have to be able to tell from those facts how the trial judge got to the result that the trial judge reached. So based on these facts, how did the trial judge get there?
Sure, and we can go back to what is necessary to make this finding. It goes back to the best interest factors. And Mr. Lewis touched on this a little bit. It's not just about checking the boxes. It's not a sporting event where we tally up wins and losses and see who has the most. The cases are very clear that even one factor could be the deciding factor. And that's what happened in this case. We have a history of Mother being the primary caregiver of these children. She had 70% of the parenting time. She was the primary residential parent. Leading up to this case, leading up to the trial court made a specific finding that the mother has historically been the primary caretaker, and separately that the children appear to be thriving in their current environment, which is stable and suitable. So, and if you look at the cases that interpret these, one on the far end of the spectrum is this case Irvin v. Irvin, where the mother was designated primary residential parent and had a majority of the parenting time. Father appealed because mother had done some contemptible things during the divorce proceedings. The appellate court specifically found that the mother had egregiously and unjustifiably interfered with the father's relationship with the children. The mother was an alcoholic at one point during the divorce. The mother had a questionable relationship with some man that the father didn't approve of, and there may be one or two other things that I can't think of right now. Regardless, the Court of Appeals, this court, said, really, we may not, lying in the record, the mother's perjury as well. And the Court of Appeals said the mother's conduct throughout this case may have led us to a different result than the trial court. But the trial court did find that mother had been the primary caretaker of the children and that the children were thriving in their current environment and that it was a stable and suitable environment. And those are the most important factors. And that's what this court, more than a decade ago in Irvin v. Irvin, said pushes it over the edge. That's all you need to make that finding, and that's what the court did in its order here. Getting into alimony, just respectfully, if we can go through the numbers, $1,500 a month is not even sufficient to meet mother's basic needs. There's evidence in the record that mother's rent, utilities, and phone bill exceed $1,500. This doesn't include anything for medical care, for transportation, for clothing, much less any quality of life expenses or anything that she may need to do with the children. This alimony award is grossly undervalued, and like the Folger case, this court should find that it is illogical and a gross departure from any reasonable alternative disposition.
All right, thank you, Mr. Griffin.
Thank you.
Mr. Lewis, your rebuttal.
Yes, sir. Before moving to the alimony argument that was made, I want to touch on one of the last things that was discussed, which was the Irvin case. In that case, I would submit to Your Honors, much of what was testified there, questioned relationships, potentially distruthful. Your Honor touched on the situation that was testified to and some allegations that came up and people who testified at trial regarding mothers, allegations of sexual misconduct, relationships she was having during the trial and during the divorce, leaving the children unattended with other minors. All of these things certainly could lead this court, as the court opined in Irvin, to reach a different result. And that's exactly what our position is that because of the lack of finding of facts, this court could reach a different result. The difference in Irvin was there were findings of fact the court made. So this court couldn't overcome the abuse of discretion. In this case, because of the lack of finding of facts, as we submit in our brief, this court can reach a different conclusion if it so desires. So I think the Irvin case is as cited, is certainly relevant in that many of the facts are comparable, but there's a different outcome this court could reach because it could, through lack of findings of fact under 52.01, could reach a different conclusion if it felt that was appropriate. As to the alimony argument, I think the question that was asked initially is the most appropriate, which is what proof is there? What proof does this court have, or what proof was submitted to the trial court to make any determination regarding alimony? I will point that there is, in the exhibits, there's 45 exhibits at trial. None of those contain a list of expenses or anything that the mother needs to support her argument for alimony. In the court of Beck v. Beck, it's a 1996 case, this court looked at a similar situation where mother in that case had failed to present any proof of her current needs. And the court noted there that although there were 36 exhibits, 3 volumes of transcripts, there was nothing that suggested or set out mother's needs for food, clothing, telephone, health insurance, gasoline, utilities, anything of that nature. And the court ultimately found there that there was no proof before it as to what the mother needed, and therefore it couldn't award any alimony. And certainly any award of alimony, and this is, I think, a big thing, any award of alimony in excess of a need for a party is punitive in nature. So in this situation, the court has to look at what is mother's need for her alimony, and the court felt that it was $1,500, but I would submit that the court didn't even have enough proof to go on for that. It didn't make a finding of fact as to why it made a determination of $1,500 a month, other than that essentially was what had been paid some of what had been paid for essentially 2 years at that point. So I would submit, Your Honors, that there is no proof in the record as to mother's need. There's certainly proof as to what father was paying. There's certainly proof as to what his income was, but there's no proof as to what mother needed whatsoever. And then the issue for, I apologize, Your Honors, what was needed from the wife to be able to be rehabilitated, her testimony is in the record that she needed a few in-service hours to be able to reattain her teaching certificate. So she could have gone back to school. She even testified that there were positions she had investigated. She didn't apply for them, didn't attempt at all to get her certification back, but there were positions that she could have attained that would have paid her $43,000 during the pendency of the divorce. So I think that's where that, although again, no finding of fact, but I think that's where that $40,000 number comes from for imputed income, is that mother testified she could have made a little over that had she gone back to teach and gotten her certification. But mother very clearly testified she didn't want to do that. She didn't have a job during the pendency of the divorce and had no intention of doing so. So she could have been rehabilitated during the period of the divorce while father was paying alimony temporarily, but she was not. So we'd ask that the alimony award be vacated, and thank you.
Mr. Lewis,
Yes, sir. I'm sorry.
we've discussed the possibility that the court may or may not find the findings of facts deficient.
Yes, sir.
And typically, a remedy would be to remand to the trial court to make findings. But the trial judge, he's no longer on the bench, is he?
That's correct, Joe. He's retired. He was actually retired at the time that this case was heard, I believe.
Yeah, that's what I was thinking. So a remand to this judge would be of no avail.
Correct, because he was retired at the time that the trial occurred and he was appointed specially. I don't, candidly,
Yeah,
I'm not sure what the procedure is
I
for
think there's
that.
a 4-month window.
Okay.
Or something. I could be very wrong on that. But thank you so much.
Yes, sir.
All
Thank you,
right,
Your Honors.
that concludes the docket.